Hello, everybody. On this Monday, December 13th, I'm Spencer Mazik, and this is the Bloomberg Law Podcast, a series of interviews focusing on trends in the busy legal profession. Today, we want to discuss the copyright innocent infringement defense. Is it available in music downloading cases? Joining us in studio for today's discussion is Andrea Calvaruso. She's a partner at Kelly Dry and is chair of the firm's trademark and copyright practice group. Welcome, Andrea, and thank you for joining us today.
Thanks for having me.
So before we get to the viability of the innocent infringement defense, let's begin with what steps the record industry has taken to prevent folks from downloading music illegally.
Okay, well, the music industry obviously does not like downloading without permission, so they've done a number of things over the years, and I think they're still trying to perfect how to tackle this as the technology changes. In the beginning, they went after a lot of peer-to-peer networks, which are essentially the companies who provide the platforms so that one person can share files with another.
So, and that's like Napster, Aimster, and LimeWire. Those would be examples of peer-to-peer file sharing networks.
Yes, sorry, exactly.
No.
So those are the first. Those were the first line of cases, litigation cases. They've also tried to do other things like educate consumers, and sometimes
educate consumers how?
Sometimes they do that through going to places where there are a lot of file sharing, such as universities, and trying to get the universities to help them educate the students that, in fact, if you're doing downloading of music and it's not authorized, that's a no-no and you shouldn't do that. And then, of course, most recently, there have been a number of cases by the music industry and even the movie industry against individual downloaders. And I think that's a result of the frustration with trying to stay ahead of the technology. They shut down one form of peer-to-peer file sharing, and then they wind up with a new one. So what they're trying to do is discourage the demand. They've brought a number of many litigations against individuals who are actually downloading music and sharing music.
Well, and I want to get to the individuals using the peer-to-peer file sharing networks, but before that, I want to note that in MGM Studios versus Grokster, which is another file sharing network, that the U.S. Supreme Court held that one who distributes a device with the object of promoting its use to infringe copyright is liable for the resulting acts of infringement by third parties. So does this mean that any network that engages in this type of activity would be held liable for copyright infringement by its users? Well,
it's a very complicated analysis and it's very fact-specific, but in fact, after that U.S. Supreme Court case, the way that many district courts and lower courts have interpreted that is really, it's the question of, are you inducing people? Not is there any way that you can use your system that's not infringing, but more, are you getting
people to use the site and kind of promoting it and
right? And is your business model mostly based upon people engaging in these infringing acts, and are you taking active steps? Are you going out and soliciting people that use Napster? And is your business model dependent on that because you're getting advertising revenue, for example? So it is a very fact-specific analysis, but it is definitely still a liability for any networks out there who want to engage in this sort of encouraging people to download files without authorization.
Okay, so tell me this: how successful has the record industry been with its efforts here? Like, have many of these file sharing networks been eliminated?
Well, yeah, I was going to say it depends on what your definition of success is. I mean, a lot of the originators of this file sharing technology have been shut down. Napster actually changed its format. But what happens is the technology kind of almost adapts to fit what is prohibited from the last case. And I think that's why the music companies are now trying to go after the infringers. One thing that has been successful, I think, is that it's gotten the message out there to people. And I think that was really part of the plan on the music industry's from the music industry's perspective is let's get some lawsuits out there and let's let individual downloaders understand that this is not legal activity.
Yeah, because I was going to say, with social media usage on the rise, it seems like there would still be a ton of other ways in which folks can share music files.
Right. There's always another way, which is the constant, in the copyright bar, there's always the constant discussion of what do you do? I mean, there's always a better mousetrap, right? So I think really it's trying to get out there and educate the consumer and put a little bit of fear in the people who are downloading to try to decrease the demand. But in fact, I recently saw some sort of statistic that, somewhere upwards of 90% of all music downloaded on the internet is still not authorized. So whether or not it's actually stopping the downloading, I don't think that it's been that successful on that front.
That's a staggering statistic, sure enough.
It is.
Well, and you mentioned that over the last few years, the Recording Industry Association of America began a second wave of lawsuits against individuals. How do they identify defendants? Because there were thousands of folks who used Napster and other file sharing networks. So how do they determine who to go after?
They really use investigators who specialize in this sort of thing, and it's a little beyond my pay grade how it actually works. But they do go on. They have very sophisticated programs, and they really just track streaming, and they track internet, the volume and where it's coming from, and they track it back to a particular IP address, an internet protocol address, and then what they usually do is they sue a John Doe, and then they go subpoena the internet service provider, like a Time Warner Cable or somebody similar, and they say, now you're under subpoena, you have to provide us with these people's contact information, and then they amend the complaint to name the actual person responsible for the downloading.
Well, so for the most part, do you think that violators who could be as young as 8 years old really understand that whenever they're downloading music illegally and using one of these file sharing networks, that it's tantamount to copyright infringement?
Well, I think it is tantamount to copyright infringement because that's a very technical definition, and essentially, you're liable for copyright infringement if the copyright owner, a music company, can prove that they actually own copyrights in a registered work, and you took it, made a copy, or distributed the work without authorization. So that's copyright infringement. I think the question you're asking is there any way that you can defend yourself by saying that you don't know or you don't have the
exactly.
knowledge?
And then also, if somebody's 8 years old and they're using these sites, chances are they don't know that definition of copyright infringement. But before we get to how you can defend yourself, can you just tell us, though, under the Copyright Act, what damages can a copyright owner collect from an infringer?
Sure. So the Copyright Act obviously allows for injunctive relief, which is just an order saying stop doing what you're doing and delete all the files that you have that are unauthorized. But it also does allow for monetary damages, and there's two different ways you can get monetary damages under the Copyright Act. First, you could prove damages, and that would be by the copyright owner proving what amount of damages they suffered, which were attributable to the infringing act.
So that would be actual damages,
That would be actual damages, and they could also receive actual damages from if they can prove that the infringing party profited from the infringement. Now, obviously, those aren't great cases for the music companies because the argument is, what am I harming? What did you really lose, BMG? Really?
Exactly.
So what the music owners do is they take advantage of another form of damages under the Copyright Act, which is available so long as the work is registered within either prior to the infringement occurring or within 3 months of when the record company publishes the copyrighted song to the public. So provided those conditions are met, the Copyright Act allows for statutory damages, and that's an amount of between a minimum of $750 per song infringed to $30,000 per song infringed.
But if there's a willful commitment of infringement, then doesn't the court have the discretion to award a larger sum?
Exactly, and if the court finds that the infringement was willful or with reckless disregard for the copyright owner's rights, then the amount of the statutory damages can increase up to $150,000 per song infringed. We're talking about songs now, per work infringed. That's at the court's discretion. I don't think in any of these file sharing cases we would ever see such a thing. It would have to be a pretty egregious case. It would have to be more somebody who's actually trying to profit from these things, selling them on Canal Street or something like this. But what the copyright owners are actually doing in the music cases is generally seeking the minimum amount of statutory damages, which is $750,000.
And this is where the whole innocent infringement defense comes into play. And I understand that it isn't a defense per se as much as it's a way to minimize damages. So tell us, though, who is an innocent infringer? Okay,
so in court, according to the copyright law, there is a way to reduce the minimum statutory damages allowable. And that is if a defendant can prove, and it's their burden of proof, that they did not know that what they were doing was infringing, and that they had no reason to believe what they were doing is infringing, then the law allows the court to reduce the damages to $200 per infringement from the normal minimum of $750 per infringement.
Which saves, I guess, the infringers quite some money, depending on how many songs, since we're talking about songs in this case, how many songs were infringed.
Exactly.
Well, and so under the Copyright Act, though, when is this defense unavailable?
Well, one of the times, which is most relevant to these file-sharing music cases, one of the carve-outs in the copyright law for this innocent infringement defense is that the innocent infringement defense is not available if we're talking about a phonorecord, which tells you how long ago this Copyright Act is written, but for our purposes, a CD. So if you're dealing with...
I might want to ask you, what is a phonorecord? I'm kidding.
That even predates me, believe it or not. But essentially, what the carve-out is that an innocent infringement defense is not available if the infringed work is a CD, for example, a music recording, and the copyright owner placed a proper copyright notice on the CD in the form that they publish it. So in other words, so first, what has to happen is the copyright owner has to place a proper copyright notice on the CD before it's published, and the defendant has to, the person who took the music, has to have had access to that notice. Okay, and I want to know this, though. Is there a uniform method to provide notice to consumers, copyright notice to consumers for digital music files? You know, I think that just because they want to put the notice out there, if you go to an iTunes or if you go to an authorized site, I'm sure that you will find copyright notices at least displayed at the place of the downloading. It'll be very obvious to you that you have to pay a royalty or you have to click through certain, click wrap licenses in order to actually download the file. But when you're on a peer-to-peer network, as far as I know, these people are not taking the time to place a copyright notice. So the copyright notice may be on the CD that the music company sells, but once that CD is downloaded into digital format, does not necessarily bear a copyright notice. Okay, and with that, let's talk about the case of Maverick Recording Company versus Whitney Harper. On November 29th, the U.S. Supreme Court denied review of this music downloading case. But before we get to why, can you tell us a little bit about the facts, what happened here? Sure. So in this case, there was a 16-year-old girl who downloaded hundreds of files from different peer-to-peer file sharing networks. Through their regular investigations, the music companies found out about it. They ultimately found out who was responsible for the downloading, and they sued. They sued in district court, U.S. District Court, and they sought the minimum statutory damages, $750 per song. The defendant, Ms. Harper, didn't really deny that she had downloaded most of these files. So there were a number of files that there was no question that they were downloaded through a peer-to-peer network and that weren't authorized. But what Ms. Harper argued was, when I downloaded these, I thought I was just listening to music on an internet radio. I didn't realize I was downloading these. I didn't have any reason to think that I was infringing anyone's rights, and therefore I'm an innocent infringer. So the judge should reduce the damages. Okay, and then, so I understand that the record companies then moved for summary judgment for $750 per song, and then also for an injunction from further infringement. Does the district court grant this motion for summary judgment? At the district court level, the judge granted the summary judgment motion with respect to the liability. So the judge said, we agree, doesn't seem to be any dispute that Ms. Harper did download these songs and it was a copyright infringement. However, we do have a question about whether or not she's an innocent infringer. Yeah, I remember the court saying that although the notice appeared on the cover of the CDs, that there was an issue of material fact as to whether or not Harper was an innocent infringer. So what happens next? Well, essentially in the district court case, I think it's just important to point out that what happened was the music companies responded to the innocent infringement defense and said, well, because of Section 402, the carve-out we just discussed, that innocent infringer defense really isn't available to you, Ms. Harper, because we put the copyright notices on our CDs and you had access to them, and therefore you can't assert this defense. So the district court said, well, you know, as you just mentioned, Spencer, we don't know if this is really a slam dunk case here. You know, we don't think that the copyright notices were on the digital files that Ms. Harper looked at. So there is a question as to whether or not she actually had access to the copyright notice. And if she did not have access to the copyright notice, then we have to examine whether or not she's an innocent infringer, which would get into, was she naive? Did she not know? Did she have any reason to know she was copying these things? So, of course, the music companies appealed, and they brought the case before the Fifth Circuit.
And so now we're before the Fifth Circuit Court of Appeals, which actually affirms the district court's grant of summary judgment on the ground that the defendant did infringe the song recordings at issue, but it reverses the district court's finding that there's a disputed issue of material fact with respect to the innocent infringement defense. And why is that?
Well, the district court didn't agree that there was a question of fact, and it's interesting and it's unfortunate, I think, because the reason that the district court didn't agree was because the court found that.
Well, is it the district court that didn't agree, or the Fifth Circuit?
Excuse me, the Fifth Circuit didn't agree with the district court because what happened was Ms. Harper, on appeal to the Fifth Circuit, did not argue that she did not have access. What she needed to do was argue, yes, court, as a matter of fact, there was no copyright notice on the digital download, and therefore I didn't have access to these CDs. I'm 16 years old. I don't buy CDs myself. I had no reason to know.
Well, so do you think that the outcome, though, would have been different had she said, look, you know, I don't have any CDs. I don't have access to them. There are no music stores in my neighborhood. Like, might the outcome have been different?
It might have been, and I think that's really the interesting question, because what we're doing is we're trying to interpret Section 402, which says that as long as there's a copyright notice on music, essentially, that you can't claim that you're an innocent infringer. We're trying to interpret it in a whole new world than when the statute was drafted, because at that time everybody bought CDs, phono records, albums, in hard copy, and nobody dreamed that, you know, someday they would just be these little digital files floating around.
Yeah, I think this provision was actually adopted in 1988, which was well before the internet age of music downloading and everything. So
exactly.
But so Whitney Harper, as I mentioned earlier, sought review with the U.S. Supreme Court, and her petition was denied. Any sense as to why the U.S. Supreme Court didn't decide to review this issue?
I think it's interesting for a couple of reasons. I mean, we never will know why the Supreme Court does what it does, but there is not a split in the circuits right now, which is a usual reason for the Supreme Court to take up issues like this on the cutting edge. And obviously, the other justices, other than Justice Alito, who dissented in not granting certiorari or review, the other justices obviously didn't think it was a unique, cutting edge enough decision that was going to have a wide impact. I think a lot of music industry executives and downloaders would probably disagree with that.
And you mentioned that Justice Alito dissented, and he said that he would have granted review of this petition just to determine whether or not Section 402D applies when copyright infringement involves digital music files. But what's the rationale behind his dissent?
Well, Justice Alito, and it's interesting because the Seventh Circuit, there was a Seventh Circuit decision years ago which was very similar, and the Seventh Circuit decision denied the innocent infringement argument, and essentially the judges in the Seventh Circuit said to the defendant, well, you could have gone out and found that this music had copyright notices if you really even made any effort at all. And that defendant in 2005 tried to get review by the Supreme Court, during which time Justice Alito was not on the bench, and they denied cert without anybody dissenting. But I'm sorry, that's just a diversion. But the interesting thing is, I think Judge Alito obviously has an interest in interpreting the statute and believes that there's going to be other cases that come down the line. I happen to agree with him. What he said was, well, we have to try to figure out how to interpret this Section 402 in this digital age. So it may be that placing a physical notice on the CD that is sold in record stores may not be enough. And the question he poses is, well, is that enough? Is it enough that it's on the record itself, and then does the defendant now have a separate duty to go and search to see if this is copyrighted? Or Right, or should we interpret it as I think Justice Alito would, I don't know, but from his dissent, seems to suggest that, well, the purpose of this copyright notice is to put people on notice. So if it's not appearing on the download where the individual infringer is going and receiving the file, then they really aren't on notice. And essentially, I think he's suggesting that the interpretation of the Seventh Circuit and perhaps the Fifth Circuit is that you're actually placing an added extra duty on the defendant to go check to see if there are, copyright notices on things that they're not even necessarily using to download the music. So I think it's...
Yeah, are we tasked with going to, the music store to find CD covers and then seeing the notice on that before actually downloading a song on a peer-to-peer file sharing network?
Exactly, and good luck finding a music store these days.
Yeah, exactly. Well, I wanted to ask you, though, what does this case say, if anything, about the viability of the innocent infringement defense or argument in music downloading cases?
I think it's interesting for a number of reasons. I think that, first of all, it's important to remember that it's just the threshold. And what this means is that if ultimately a court decides that just because a record company puts a copyright notice on a physical copy of a CD does not mean that a digital downloader is on notice, such that the innocent infringement defense is no longer available, then you have to get to the next hurdle, which is the person an innocent infringer? Does this person not know, and did they really have no reason to know that what they were doing was copyright infringement? And I think there are actually very few defendants in this day and age that will probably fit into that category. I think your 8-year-old example, it probably fits. And I'm sure most parents hope that fits because they'll wind up being responsible. But I think what it also does, so it sends a signal, number one, to defense attorneys that you better argue that your client doesn't have access to the copyright notice, but it also sends a message to the music industry to up your efforts to put the world on notice that these downloads are not allowed and that they're infringing. I mean, perhaps they have to go now from as children get more sophisticated, they have to start bringing this not only to the universities, but to, the high schools and the grade schools. And so that when some innocent infringer argument comes up, the music companies can say, well, everyone has heard about these cases. Even 8-year-olds learn in school that it's not right to steal other people's music. So.
Oh, wow. Such interesting stuff, but we're going to have to leave it there. Thanks so much for joining us today and for your insight. I really appreciate it.
Thanks for having me.
When we come back, our spotlight on contributed content. Back in a moment.
Digital technology has transformed the way we live our lives. We can access any piece of information at any time from anywhere. We can share ideas with thousands of people instantly. Staying up to date with breaking news and events is easier now than ever before. All this lets us keep pace with the world in real time. Yet, have any of these innovations been applied to the way we research and practice law? Starting today, the answer is yes. Welcome to Bloomberg Law, the first and only real-time research system for the 21st century legal practice, created by the leading provider of data and information services. A single search feature with access to legal, news, and company databases provides you with powerful legal research results and a holistic view of your clients, filtered so you know the information you receive will be relevant every time. Customizable legal, financial, and news alerts keep you ahead of your clients and in tune with their world. An integrated workspace allows you to organize your results by client, by urgency, by topic, however you want it, and to share those results with people on your team. Log in now to experience Bloomberg Law.
Now it's time for our Spotlight on Contributed Content. This is a segment where we highlight an article that was featured in one of our Bloomberg Law reports. Today's article comes to us from Robert Zelnick and Corey Anvirapur of McDermott, Will & Emery. The title of the article is, "Who Are You Calling a Bully?" The article explores whether large companies are engaging in so-called trademark bullying or if the policing of their trademarks is just smart business practice. You can find this article in the December 13th issue of our Bloomberg Law Report, Intellectual Property, on the terminal at IPLR Go or at BloombergLaw.com. Articles are contributed to us for publication by practitioners, law professors, and other legal experts. To find out more about how you can contribute, please visit BloombergLaw.com. A special thank you to the McDermott authors for that contributed piece. And again, our thanks to Andrea Calvaruso of Kelly Dry. Bye, everybody. Whoa.